Second speaker this evening is Gowri Nanayakkara from Canterbury Christchurch University, who's going to talk about Hello. It's the singers from the other side, Sinhala Singers Performers' Rights Dream. Thank you,
Charlotte. Good evening, everyone. Add to this evening's theme on performance rights, my presentation today is a brief a comparative study. I think it's a bit of an exaggeration to say a comparative study on performance rights in music between UK and Sri Lanka, but focusing particularly on the Sinhala singers. I examined performance rights, its implications, and the expectations of it from the standpoint of the Sinhala singers in Sri Lanka for my doctoral thesis. In that, I also examined whether the situation in Sri Lanka is distinctive compared to the UK, the US, and India. But today, I'm only going to focus on UK, but mostly on Sri Lanka. So, performance rights regime, I used the phrase PRR for that, in Sri Lanka was first introduced in 2004. Never heard of performance rights before that in that part of the world. So in 2003, the Intellectual Property Act number 36 of 2003 introduced performance rights for the first time as a result of Sri Lanka becoming a member of the WTO. The need to make the national IP regime TRIPS compliance had to bring in several amendments to the existing law. Sri Lanka is not a member of the Rome Convention and the WPPT. Judge Arnold mentioned about the international field of the performance rights earlier today. Although we are not a party to either of those conventions because of the membership with WTO, performance rights were introduced. On the back of that, it was also noted during my empirical work that Sri Lankan Sinhala singers particularly were strongly lobbying for performance rights to be included in the new, well, not new anymore at the time, in the IP Act. To look at the right itself, you'll see I've listed the main points. So Judge Arnold earlier went through a long list of economic rights for UK performers under the CDPA. We don't have such long list of rights, pretty basic, right to authorize broadcasting or communication to the public, right to authorize fixation, right to authorize reproduction of fixation, and very importantly, the equitable remuneration right. There are no moral rights introduced under the performance rights regime in Sri Lanka, although there are for authors. So with that brief engagement with the right itself, in my empirical work, when I wanted to look at the introduction of performance rights and the expectation of the singers in terms of that regime, I questioned them as to what the concerns they were encountering that they felt that the performance rights could address and resolve. So two main problems I understood by talking to them. Firstly, and very, very, very interestingly, majority of the singers I interviewed were against the practice of covering. They expected the performance rights to legalize or ban, not legalize, ban covering in the music industry. I thought that was very interesting. The second question they had was about the known question of economic certainty through royalty pay. Live performances are paid for and are quite lucrative for singers, but royalty pay was not something that was materialized or is materialized at the moment. So they expected the performance rights to introduce some form of royalty payment to them. Now, when I dig deeper into these two issues, I wanted to find out the reasons behind this objection towards covering. And I found out that the historic reasons, several historical reasons may have contributed to that, but very, very importantly, I think the emergence of the music industry, which was predominantly based on Indian cover songs in the early 20th century, could have played a part in that. When all the songs or majority of the songs you hear in the radio are Indian cover songs and not works created by with a singular flavors, local flavor, there was this stigma that was being created about covering. Not until the 1950s, when the nationalization of music started to happen, do we hear a music of our own, if I were to use that word, or original, as some would refer to it. So it seems like the strong views that were there at that time against these Indian cover versions perhaps sort of lasted more than, beyond that period as well. And we still today feel that covering is a substandard creative work and not an actual creative process. So today you will, because of these objections, you won't hear many Sinhala cover songs in the Sinhala music industry, although you would hear lots and lots of Indian cover songs still, and also a lot of English cover songs as well. Now, the other interesting finding was that as a result of this, the conditions within which the music industry emerged, paved way for the singers to become prominent within the music industry. We heard from Judge Arnold and also from Alane how the performers are at the bottom end of the value chain. What I noticed in the Sinhala music industry is it's the other way around. The singers are in a far better position financially and otherwise than the authors of the music industry. And again, I connect that position to the historic reasons. Now, during the cover version era, the gramophone industry era, when Indian songs were covered, the local lyricists and local musicians' creative contribution was quite limited because the melody is already there. And then when the lyricists tried to incorporate Sinhala terms to sync in with that melody, to sound a bit like the original Indian version, sometimes some authors were criticized for ridiculing the language. The literary quality of such songs were considered as quite minimal. But on the other hand, the performer, the singers, were embraced as, creative geniuses, contrary to how the authors were perceived. And connected with that, some of the industrial practices at the time where, for example, the Radio Ceylon, the first radio in Asia, kept on paying for singers for the performances they made for the radio, but never to the authors. So what I noticed was this distinctive conditions in Sri Lanka where singers are financially in a stronger position, higher up in the value chain, and also more powerful than the authors in the industry. So looking at the second issue they were complaining about, royalty. There is no royalty payment scheme for authors or singers in Sri Lanka, even more than 10 years since this act was introduced. When I talk to some of the singers, those who are still active in the industry, who are making performances on a regular basis, they're not that all bothered about this minuscule payment you would get through royalty share. What, in their words, what they say is, if we get it, that's a bonus, but I'm not going to fuss about it. That's exactly what they would say. But they all say how a royalty payment scheme would be quite helpful for the aging artists who are not in a position to make these lucrative live performances anymore, who are staying at home, unable to make any form of money. So they feel that this could be a good, maybe not as great as you would want it to be, but some sort of a pension scheme, and therefore still lobbying for it. So for today's talk, I thought I would focus a little more about covering, and because we're here today, I thought I'd just connect it with the UK situation as a brief comparison. So covering is not something new to this part of the world. I mean, to give a couple of examples from the recent past, I particularly liked Alexandra Burke's rendition of Leonard Cohen's Hallelujah, which has, by the way, been covered by many, many artists such as John Cale, Jeff Buckley, Rufus Wainwright, Alison Krauss, Bon Jovi, and even Bob Dylan. Another example I really like is Lily Allen's rendition of Kian's Somewhere Only We Know. I'm sure you may have your own, favorite covers as well. So my point is there is a substantial market for covering in this country. Yes, there are licensing requirements. As long as you follow those, as long as the authors and owners are happy for you to do those covers, that is doable. The singers, unless they are the singer-songwriters, would have no say in the matter whatsoever. The US situation is, I think, a little more liberal than here, but the fact that there is a substantial market for covering is a known fact. But the situation in Sri Lanka is quite different. There are significantly limited number of Sinhala covers you will hear, even on those limited occasions when a singer attempts to cover someone else's song, they would be frowned upon. There will be newspaper articles all over criticizing that act. How dare she, how dare he, all that. So there's still some level of stigma attached. It is considered as something that only an amateur would do, not an established artist. And it seemed, from talking to these artists, that there is some form of a silent agreement between singers, where they say, don't cover my songs, I won't cover your songs. Let's just stick to our repertoires and just perform our own songs. So in other words, they're expecting some form of an exclusive performance right, which unfortunately is not what performance rights are about. And the other side of this issue is that authors, on one side, are not financially remunerated. They only get, if they're lucky, a one-off payment when they write the song for the singers. No royalty share thereafter, but the singers get the opportunity to perform them again and again and again in live concerts and in other venues, and make a living out of that. So, and in terms of covering, nobody's even attempt to, majority of the artists who would want to do covers wouldn't even attempt to approach authors because they don't want to be labeled as people who are copying other people's work. So there's this expectation that you would create a new work and perform rather than performing something that is already there. So again, I felt it's quite an interesting distinction in terms of covering. So what I understood through this research is that although the Sinhala singers expected the performers' rights regime to bring some form of solution to them, it ended up creating further problems for them. Because as we know, performance rights are a subcategory, a secondary right to copyright. The hierarchy, the creative hierarchy, the copyright regime enforces, only gives the singer the second place, whereas the copyright holder, the authors, the top place. So when singers expect and lobby for this enforcement of performers' rights, what they're actually getting is a raw deal. They're actually becoming far worse than where they are at the moment. And this has also led to difficulties surrounding royalty share, because every attempt that has been made to create a royalty payment scheme where they collected all artists, authors, and singers to discuss how royalty share could be divided, there's a strong objection by the singers where they say that not a share from my fee should not go to the authors, because they are not coming with us to the concerts. They are not going to be sleep deprived every night when we perform. They have just written it once, but we perform it again and again and again. So the author should not get a share of that pie, is basically what they're arguing. So this has led to a royalty scheme being introduced into a court. So it's a very interesting situation at the moment there. So, but what I want to conclude with is that performance rights, how it's developed internationally and implemented in Sri Lanka is predicated upon a particular understanding of the role of performers and their relationship within Sri Lanka's contemporary music industry. But as this study showed, this understanding did not reflect the Sinhala vocalist role or their relationship within the Sri Lankan music industry. And this has led to performers' rights being unable to deliver the expectations that the Sinhala singers had. I'll conclude by saying that. Thank you.